Hi everybody, and welcome to our November Seminar Series. This one is being held in hybrid. Before we begin, I'd like to start by paying my respects to the traditional owners of the land from which we kind of are all seated and kind of getting ready to watch this presentation, the Wurundjeri people of the Kulin Nation, and pay my respects to elders past and present. I'd also like to extend that respect to the lands that kind of you're joining us from, and to any Aboriginal or Torres Strait Islander people who are here in the audience today. Let's get started. I won't take up too much time before our speaker starts. So today our seminar will be on assessing an unacceptable risk in individuals convicted of sexual offences, but of course you all knew that. Before we begin, I have like a standard kind of spiel that I run. If this is your first kind of seminar that you're attending, or if you found out about the seminar through someone else, we do run these seminars more or less monthly. We have a lineup of really kind of excellent talks. All of our talks really relate to research, or the most recent research within the kind of forensic behavioural sciences and associated fields like law and criminology. We bring in kind of leading researchers to really kind of explain the most recent kind of findings or the most recent research they've been developing or working on. So it's a really good opportunity to keep up to date with the research landscape in this area. And if you do want to kind of never miss out on one of these great seminars, you can see the email before you on the slide. Send an email just directed to that address, just indicating that you'd be interested in joining our mailing list. In addition, there's all sorts of other kind of promotional sort of stuff we'll send through, but we promise not to spam you. Okay, wonderful. So let me introduce our speaker. We're really lucky to have Associate Professor Emily Gottfried coming for today's seminar. Emily comes all the way from the United States, and she's one of those people who's both a practitioner and an academic. She's a licensed clinical psychologist in South Carolina and Georgia, and currently is an associate professor of psychiatry and behavioural sciences at the Medical University of South Carolina, where she also serves as director of the university's Sexual Behaviours Clinic and Lab. In that role, she conducts both kind of academic and clinical work. So she conducts sexual violence risk assessments referred by courts attorneys, and she frequently provides expert testimony on sexual behaviour and penile plethysmography. I'm not even going to try that. Dr. Gottfried also conducts treatment and risk evaluations and provides specialised sexual behaviour treatment for individuals under state and federal supervision, as well as for participants in the Sexual Behaviours Intensive Outpatient Program. I'm really looking forward to hearing from Associate Professor Gottfried, and I'm sure if the number of people who are attending in the audience today is any indication, you all are as well. Before we move on to the presentation, I throw to Emily. Just a little bit of housekeeping. If you do have questions and you're online, hold your questions to the end, but throughout the presentation, you can enter your questions into the chat. And following the presentation, if we have time, I'll put those questions to Emily to answer. Okay. Apart from that, I'm going to switch slides and please welcome Associate Professor Emily Gottfried. Take it away.
Perfect. Thank you. Right. So I'm Emily Gottfried. This is my first time in Australia, and I'm really excited to be here. Today, I'm going to talk about assessing unacceptable levels of risk in individuals who have been charged with and convicted of sexual offenses. I have some pictures of my university and Charleston, South Carolina on this slide. A little bit of background. So today I'm going to talk about different post-conviction management schemes, particularly the one here in Victoria, and then also comparing that to prison sentence management schemes in Queensland, in the United States, and some other international perspectives. And then we'll spend some time talking about cultural considerations that you want to make in risk assessment. So kind of my disclaimer, I did a lot of research looking at the statute on the Serious Offenders Act here in Victoria. Certainly, I'm not an expert. This is my first time kind of learning about it. So if I say something incorrect or get something wrong about that statute, that act, please correct me. I'm really interested in the way other countries do things, so that's really important to me. So here in Victoria, there's the Serious Offenders Act, which was passed in 2018. And this is an individual who has already served a custodial sentence for certain, what they call serious, violent, or sexual offenses. And then a court determines that they pose what they call an unacceptable level of risk to reoffend after their custodial sentence. And so they would require either a post-sentence detention order or supervision order. And just a little bit of history of the act that I looked into. So initially in 2009, there was the Serious Sex Offenders Act, and that was only for individuals who were convicted of sexual offenses. And then in 2015, unfortunately, here in Melbourne, there was the murder of a 17-year-old girl, and she was killed in a local park by a person who was a stranger to her. She was stabbed 49 times. And this Mr. Price, the person convicted of her murder, had served a custodial sentence. He was currently out on bond for another offense, but he was given a supervision order in 2012 for 10 years. And so during his trial, it came out that he had attacked 7 women. He had raped 2 of them, one being a 13-year-old girl and one being a woman home with her children. And he essentially said that he had the urge to kill somebody. He didn't like society. And so he selected this random stranger in a park and then proceeded to go on what they called a 2-day crime spree, where he raped a woman, committed robbery, a number of things. And so that happened in 2015. And so I have some quotes from local news agencies about how they called his kind of failure to be supervised this catastrophic example of mismanagement. And this led to them reforming that act from 2009. So the Premier noted that they tragically failed this victim and her family, and that they would go on to fix the system that failed the family. And so there was a Harper review, which to my understanding is like an expert panel review, and that happened in 2017. And from that review, the act was changed to the Serious Offenders Act of 2018. And so previously, individuals who were on supervision orders were supervised from or by the parole board. And so this created a new post-sentence authority, or the PSA. It also expanded the Serious Offender Act to include individuals convicted of violent offenses, so not just sexual offenses. And then they created a multi-agency panel to coordinate services for these individuals under supervision. And the reported goal was to give the post-sentence authority dedicated oversight for these, what they called serious offenders, who were on post-sentence orders. And so they said that the goal was to focus on community safety as well as rehabilitation. And so from the statute, I learned that the purposes of the act are to primarily provide enhanced protection for individuals who pose what they call an unacceptable risk, or who may pose an unacceptable risk upon their release, and that they require ongoing either detention or supervision. They wanted to facilitate treatment and rehabilitation efforts, and then also this repealed the act from 2009. And so in order to be eligible for consideration under this post-sentence management scheme, the person has to be at least 18 years old, and they have to be serving a custodial sentence for either a serious sex or violence offense here in Victoria. And so the courts are tasked with assessing whether that individual poses an unacceptable risk of committing another relevant offense if they were released without continued detention or supervision. And unacceptable risk is defined as a degree of risk that cannot be sufficiently managed through supervision in the community. And so the court can determine that that person has this unacceptable level of risk requiring supervision or detention, and that risk can be less than more likely than not. Okay, and so an individual who the court finds poses this unacceptable level of risk can be subjected to either a detention order or a supervision order. And so detention orders appear to be much more rare. The majority of people are on supervision orders, but individuals are eligible for detention order if there's evidence to a high degree of probability that they pose or will pose an unacceptable level of risk. They are committed for this post-sentence period of detention after they've been released from prison. And then that order is good for 3 years unless it's revoked sooner. But after the 3 years, or at any time before those 3 years when it expires, then they can apply to the Supreme Court to renew that order. And DPP on this slide is the Director of Public Prosecutions, and that is the person who would apply to the Supreme Court. And then in contrast, supervision orders are what the majority of individuals who are SOA people are on supervision orders. And so let's see, this lasts a period not exceeding 15 years unless it's revoked before that. And again, they can apply to extend that before it expires. Okay, so that is related to the Serious Offenders Act here in Victoria, but in other jurisdictions, other countries, there are similar schemes for managing individuals post-sentence. So in Queensland, there is the Dangerous Prisoners Act of 2003, and that is specifically for individuals who have been convicted of certain serious sexual offenses. And that allows the Supreme Court to do continuing detention orders, and they also do supervision orders as well. And it applies again when there's this unacceptable level of risk of the individual committing another sexually violent or sexual offense. How easy this is to read. So I wanted to do some comparisons. So this table is comparing the Serious Offenders Act here in Victoria and comparing it to the one in Queensland. Let me see what I want to highlight. So in my kind of review of both of these acts, it looks like the one here in Victoria may have been modeled after the one in Queensland. I also noted that the act in Queensland is one of the strictest ones in comparison to other parts of Australia. Yeah. Okay, and now heading to the United States. So in the United States, in 19 states in our federal system and in Washington, D.C., we have a version of either a sexually violent predator or a sexually dangerous person act. And so that provides for the indefinite civil commitment for an individual who is found to be a sexually violent predator or a sexually dangerous person. And it varies based on which state you're in, what that exactly means. I do these evaluations in South Carolina, and so the wording is pretty similar across the states and the federal government, but I put the South Carolina statute up there. So this is an individual who has been convicted of a sexually violent offense, and that's defined in our statute. So we don't have to, make a judgment of what's sexually violent, what isn't. And then they are found by a court, typically a jury in South Carolina, to have what we call a mental abnormality or a personality disorder that predisposes them to acts of sexual violence and makes them likely to reoffend if they're not committed to a psychiatric facility for treatment. And then I have a table comparing the Serious Offenders Act here in Victoria to the United States. I think the main difference is that here in Victoria, it's about risk level, and it has nothing to do with whether or not the person has a mental illness that's related to increased risk for sexual recidivism. But in the United States, we can have somebody who has an incredibly high score on, say, the static 99R, but they don't meet diagnostic criteria for a paraphilic disorder or a personality disorder, and therefore they wouldn't qualify under the statute. It has to be related to a psychiatric disorder. Most of the states use clear and convincing evidence in determining if somebody meets the statutory definition for being a sexually violent predator. South Carolina is one of the only jurisdictions where it's beyond a reasonable doubt. And that standard for evidence is typically reserved only for criminal cases. But because these are such significant liberty issues, taking somebody who maybe served a 30-year prison sentence and then civilly committing them indefinitely for treatment, they have a very high legal standard for that. So in South Carolina, it's beyond a reasonable doubt. Okay, and then I was interested in other international approaches. So in England and Wales, they have the offender personality disorder pathway. And if an individual is found to be eligible under this act, they're detained and treated in high security hospitals and prisons. And they have to find that the person is more likely than not to commit another violent offense within 5 years. And interestingly, to me, in England and Wales, it's related to personality disorder diagnoses. And I couldn't find anything about if somebody has a paraphilic disorder and not a personality disorder. This is specific to the offender personality disorder pathway. And then in Germany, this is part of their criminal code. So an individual is sentenced to a custodial sentence, and then that expires. Then they can do an indeterminate preventative confinement sentence based on their risk for recidivism, balancing public safety. And then in Canada, they have the High Risk Offenders Initiative. So this is built upon the DO classification, the Dangerous Offender classification in Canada. And so DO is not related to sexual offending. It can be any violent offense. And so if a person is found to meet the criteria under the High Risk Offenders Initiative, part of the Dangerous Offenders Act, then they can have an additional 10 years of supervision added to their sentence. And these are individuals who the court has found that they present a continuing threat to the life, safety, or physical or mental well-being of another person. So although dangerous offender designation is not specific to sexual offenses, the statistics show that 85 to 90% of individuals classified as a dangerous offender have been convicted of sexual offenses. And so their cases are reviewed 7 years after the offense and then every 2 years after that. Okay. So I want to turn now and talk about some cultural considerations. Let's see. So regarding demographics, the only data I could find, or the most recent data I could find, were from December of 2022, where here in Victoria, there were 131 individuals who were on supervision or detention orders. Only 5 of them were women or identified as non-binary. 72% of them had been convicted of sexual offenses, where 12% had been convicted of both a sexual offense and a non-sexual violent offense. I have the victims listed. So I guess the majority of them who had sexual offenses had child victims. And then, as I mentioned previously, supervision orders were much more common than the detention orders, with 93% of individuals of that 131 individuals were on supervision orders. The average age of individuals supervised in December of 2022 was about 50 years old. And something I found very interesting is that 18% of individuals on detention or supervision orders identified as Aboriginal or Torres Strait Islander, whereas I looked at data in Victoria, and in 2021, they represented 1% of Victoria's population. So like this huge overrepresentation. Okay. And then in 2023, the Victorian Aboriginal Legal Service, or VALS, made a submission about the Serious Offenders Act. They made a number of recommendations and pointed out a lot of inequities within the act. So they said that the way that the act was currently, it was incompatible with the Charter of Human Rights and Responsibilities Act of 2006. They had really serious concerns that the act misaligned with its stated practice and purpose. They thought that the act essentially functioned as being culturally unsafe for people who are Indigenous or Aboriginal, and that it didn't take any measures to protect the right to engage with and enjoy culture. They said that it failed to take into account the importance of engaging with culture, kin, and community. And they said that as the act, as it currently stood in 2023, it only works to further harm Aboriginal people after the completion of their sentence. And so in light of this review in 2023, there was an amendment bill this year in 2025. And so one major change in 2025 was that one person on the post-sentence authority panel, which is made up of 13 people, one of them had to be of Aboriginal or Torres Strait Islander descent. And they said that that was aimed at ensuring, quote, specific needs and perspectives of Indigenous and Aboriginal people are considered within post-sentence supervision. And they said, therefore, we are strengthening their cultural rights. So also in this VALS submission in 2023, they made a number of recommendations. They recommended that the act be amended so that the individual on supervision or detention orders or their legal counsel had the ability to contest the cultural appropriateness of the risk assessment tools that was used in their evaluation. They also said that there should be funding available so that the defense team or the individual could engage what they called highly regarded experts to conduct risk assessments that are culturally safe and culturally appropriate. They recommended that risk assessment tools be developed by experts who are regarded by the Aboriginal community as being culturally safe and responsive to the needs of these individuals. And they said that the risk assessment tools must be developed in consultation with Aboriginal communities. And then a couple additional concerns that they had. They noted that there was a disproportionately high number of individuals who had cognitive impairments or mental health diagnoses who were on supervision or detention orders. And they noted that they also saw a disproportionately high number of First Nations people on orders. They noted that in their experience, people with complex needs were being placed on these supervision or detention orders that had really difficult conditions that they were struggling to meet because they did not have access to treatment options in the community that would be able to manage them in a less restrictive environment than being on detention or supervision orders. And so one of the biggest challenges that is going on in this field is that most of the actuarial tools that we use in determining whether or not somebody has, quote, an unacceptable level of risk is that they were developed using white Western samples, and they assume that those predictors generalize across culture, and the evidence does not support that. And so this isn't necessarily malicious, but evaluators erroneously assume that because these instruments are shown to predict for some people that they can translate and predict for anyone that they're not normed on. There's also the significant lack of knowledge about base rates. And so we know that the predictive accuracy of our risk assessment tools is lower when we use them with individuals from other cultures, other race groups, than the individuals who they were normed on. And across the literature, there are recommendations that there needs to be local validation of these instruments. So we know that these actuarial and even dynamic risk measures tend to show lower predictive accuracy and calibration for Aboriginal and Indigenous individuals. And that's partly because the base rates differ, and also because of structural factors like racism, systemic issues, disadvantage, and that is not like captured in our actuarial models. So when you're scoring somebody on an actuarial risk assessment, it's often looking at general criminality. So it's not looking necessarily at arousal to non-consensual, abusive sexual material, but it's reflecting these, they're getting much higher risk scores because it's reflecting these like racist policing issues that we have and other systemic problems that are accounting for why some individuals are getting arrested more frequently or at a higher rate than other people. And so that is what these risk assessment tools are picking up on and why they're putting them at higher risk when it's not really something specific to that individual. The literature suggests that until there's local validation of these risk assessment tools, that you should use structured professional judgment tools, SPJ tools, and then also kind of couch that in the context of their culture and their like development and historical factors. Okay, I also want to talk about a landmark case in Canada. So Mr. Ewart was a Canadian Aboriginal man, and he was serving 2 life sentences, but he had been eligible for parole for nearly 20 years. But he repeatedly waived his parole hearings because he did not think that he would be successful due to the expert reports repeatedly saying that he was at this very high level of risk of reoffending. And so in this appeal, or in this case, he alleged that the risk assessment tools were not culturally appropriate for individuals who are Aboriginal. And specific to this case, he was talking about the HAIR PCLR, the VRAG, the SORAG, the Static 99, and the VRSSO. Okay, so in Ewart's case, he was successful in providing that the tools were unreliable due to cultural bias. And the court held that the results of these risk assessment measures negatively impacted him by increasing his security classification and also like dissuading him from having these parole hearings. That was overturned on appeal, and then the Supreme Court of Canada ultimately heard the case, and they issued an opinion in 2018 where they said that the Correctional Service of Canada was using information that might be inaccurate and discriminatory by continuing to use these risk assessment tools without ensuring their validity for Indigenous people. He had a few other claims that the Supreme Court ultimately dismissed because they said the evidence presented at trial did not definitively establish that the tools overestimated the risk posed by Indigenous people. But I think the most important part of this ruling for Canada is that it required the Correctional Service of Canada to conduct more research or ensure that research was being conducted that looked at the cross-cultural validity of these assessment measures. And they said, if you continue to use these in your risk assessments, then you must do this research. So I think that's a really important thing that came out of this Supreme Court ruling. All right, and now I want to shift a little bit and talk about conducting sexual behavior evaluations in general, and then we'll spend some time at the end talking about conducting evaluations specifically pursuant to the Serious Offenders Act. And so essentially there is no manual for conducting these evaluations. I think you could say that about a lot of the evaluations we do, but I think when I was new to this field, really trying to figure out what are the best practices, what is the best way to conduct these evaluations. I currently serve as a board member on ATSA, that's the Association for the Treatment and Prevention of Sexual Abuse, and they have practice guidelines. So we have them for juveniles, we have them for adult men. The latest ones just came out in 2025. And so essentially, you want to think about adhering to your ethical principles, using multiple data points, so conducting a multi-method evaluation, and trying to consult and use the most empirically supported measures, practices that we have. So in general, not specific to sexually violent predator or SOA evaluations, but looking at mitigation evaluations, pretrial evaluations, risk assessment, treatment, factors that are typically considered by the court in making determinations about somebody's level of risk. You're going to think about the nature and gravity of their prior offenses. When people ask me, maybe on the witness stand, about predicting someone's risk, I usually say something like the best predictor of future behavior is looking at past behavior. So you really want to look at the offense characteristics. That's going to help you predict the likelihood of a reoffense happening, and also give you information that if a reoffense were to occur, who like the victim pool might be, the level of harm caused, or the level of injury, physical injury caused. Especially for the Sexually Violent Predator Act, because it's based on, quote, the mental abnormality or personality disorder, you really want to explore the range of paraphilic disorders, personality disorders, any other mental illness to see, okay, they have a mental illness at baseline, and then was that related to their sexual offending? And are symptoms of that mental illness still present such that it's predisposing them to commit acts of future sexual violence? And then using risk assessment instruments, I have a couple listed, and really considering the cultural appropriateness of the person that you're evaluating. Also looking at dynamic or other criminogenic risk factors, looking at their treatment history. So have they volunteered for treatment? Were they mandated for treatment? Did they participate? Did they successfully complete it or not? Looking at their behavior during their custodial sentence. So did they have a lot of disciplinary infractions? Did they demonstrate aggression in a correctional facility? And then maybe giving an opinion about the feasibility to manage them safely in the community. So thinking about like the less restrictive environment, like how can this person most safely be managed in the community? And then again, the cultural and social context. So people who do this type of work, we have a number of different risk assessment tools or tools that are specific to sexual behavior. I have some of them listed here. And then during these evaluations, we also use ones that are not specific for sexual behavior. So depending on the case, you might do IQ or neurocognitive testing. You might look at impulsivity and attention, personality tests. I really like the alternative model of personality disorders, the AMPD, that's for the DSM-5. We're going to talk about penile plethysmography. There are still places in the US, I don't know about other places, that use polygraph in evaluations. When I took over at the Sexual Behaviors Clinic and Lab at the Medical University of South Carolina, they were using polygraphs, and I stopped that kind of immediately when I took over as director of that lab. But I think that they're still used, and they're used, at least how they were being used at MUSC, to answer a really specific question. So they would have the polygrapher ask the person something like, in the last 6 months, were you masturbating to fantasies of prepubescent girls? And so looking at like current arousal. But in my opinion, that's not the most ethical way to conduct an evaluation. And I think hopefully, at least in the US, I think polygraphs are used more in treatment than evaluation, if they're used at all. And as I mentioned, I think it's really important to do a multi-method clinical assessment. So I give the individual a battery of tests, and then during my clinical interview, I ask them some similar questions that they're answering to the computer. We know across the literature that people might be more forthcoming, sitting in a room by themselves answering questions on a computer, or they might be more forthcoming in a room sitting across from somebody and talking. And I think it's really important to have multiple data points kind of looking at the same thing, looking at that convergence. And then I think it's really important to use evaluation results to inform treatment. So regardless of like the nature of the evaluation, you can take those dynamic risk factors, those factors that can be treatment targets, to really inform how this person is going to be safely managed. And I have some examples of kind of things that you can look at that can become treatment targets. Okay. So I want to talk a little bit about penile plethysmography. This is a big research interest of mine. And so penile plethysmography is a physiological measure of male sexual arousal. It's an objective measure, and we are looking at changes in the circumference of the penis in response to presenting a variety of different kinds of stimuli. And so across the literature, it's called the gold standard of looking at male sexual arousal. And so during a PPG examination, essentially, we're looking at changes in the circumference of the penis, looking at sexual arousal. So, for example, if you have a man who sexually offended against prepubescent children and they have pedophilic disorder, they're aroused by prepubescent children, then you would expect that they are going to show greater or equal arousal to stimuli featuring prepubescent children than to consenting adults. And why is this important to objectively assess? Well, we know from these huge meta-analyses that are getting pretty old at this point, but the best meta-analyses that we have on sexual risk recidivism show that sexual arousal to illegal, abusive, non-consensual material is a very strong predictor of reoffending. And so to me, the best way to find out what somebody is aroused by is to ask them. But because individuals have an understandable, well-founded reason for not being totally forthcoming during an evaluation of what they're aroused by, to me, it's an important data point to assess. And so in the ATSA practice guidelines that were revised this year, they support the ethical use of PPG. And so ethical means that you're not using it as the sole criterion for anything, right? So you're not just taking those data and saying, okay, this person must have pedophilic disorder, or this person can't be managed safely in the community, or this person is not ready for release. We're using it as one data point in the context of a comprehensive evaluation. And so when somebody is undergoing penile plethysmography, they're presented with a variety of stimuli. And so when I do PPG clinically, I tailor the stimuli to match the offense characteristics of what the person has been convicted of. So if the person has been convicted of raping adult women, then I'm only giving them stimuli featuring consenting adults and non-consenting adults, and I'm not giving them child scenarios. But they range from prepubescent children, infants, pubescents, adolescents, adults, both male and female. And then the content can range from consenting adults to persuasive, to coercive, sexually violent. And then we also do neutral, non-sexual stimuli to look at validity. And so we're comparing their level of arousal to the non-consensual illegal, abusive stimuli to their arousal to consenting adults. And importantly, in the United States, we don't have any kind of medical exemption to our federal child pornography laws or CSAM laws. So we are not using what would be child pornography. And the way that we do PPG in my lab is that it's all audio. So they're listening to somebody describe these sexual situations with children, and we're not showing them images of children or videos of children. But other countries, Canada has a medical exemption to their CSAM laws. I looked it up for Canada or for Australia, and it looks like, and please correct me if I'm wrong, it looks like there might be a medical exemption if they're not actually real children. So if it's like AI produced or something that doesn't represent an actual individual child, that is not against the law, but anything featuring a real child, that would still be against the law. This is what a PPG output looks like. So the line at the bottom, the black one, that is the P gauge. So that is the penile gauge that the person has placed around their penis. And this is showing somebody getting aroused in response to the stimuli. We also use some countermeasures. So the blue is respiration. So we can see if they're holding their breath. We can see if their breathing changes. The yellow is movement. So they're sitting on a pad. It's pretty sensitive. So we can see if they're flexing, if they're squirming. Another thing that I really like these countermeasures for is if somebody, let's say, sneezes really violently, that can move their penis. And so it might look like arousal, where I can see in the other physio data that is an arousal. That person like moved quickly or sneezed. And then the green is galvanic skin response, which I've scoured the literature and I cannot understand like why they added that, what I'm actually looking for as a countermeasure. So in honesty, when I'm interpreting a PPG, I take that green line and just kind of move it up because I don't use it for anything. So as you can imagine, there are some issues with PPG. I'd say the two biggest ones are that there's a lack of standardization across sites and that some individuals don't show what they call the expected arousal pattern. And so for the lack of standardization across sites, one major issue in standardizing is that different countries can do different things. So my lab at MUSC has a sister lab at the Royal Institute for Mental Health in Ottawa, Canada, and they can use something that would be classified as CSAM or child pornography in the United States. And so it's difficult when there's a lab that's been operating for 50 years, for a long time, using the same methods. It's really difficult to kind of convince them to change their methods because our lab can't do the same, way that they do it. So that is an issue with standardization, which we're trying to work on. Maybe 7 or 8 years ago, Paul Federoff, Lisa Murphy at the Royal in Ottawa established this international standardization work group where we have other doctors from the UK, from Czech Republic, Canada, the US, like trying to work on standardization. But again, because of those differences between laws and countries, it is difficult. And then regarding that some individuals don't show expected arousal patterns, to me, this makes sense. Like not all men who have offended against a prepubescent child offended because they have pedophilic disorder. And so we would expect that somebody who has pedophilic disorder is going to show arousal to prepubescent children. But we know that people offend for a variety of reasons, and paraphilic arousal is just one of those reasons. And then to present a little bit of data on PPG. So Ian McPhail in Canada in 2019 published a really great meta-analysis looking at 91 studies that included a lot of these large groups. So there was 4,700 men who had sexually offended against children. There was over 2,000 men who had not offended against children, 541 people who had gone on to have a detected sexual reoffense, and over 2,000 people who were not detected to have reoffended. And then they split up the stimuli into a couple different groups. So pedophilic or prepubescent children under the age of 13. Abaphilic was 13 to 15-year-old children. And then they had this combined group, and that was for studies where in their method section, they just referred to the stimuli as children, but didn't list the age of the child, and then looking at adult stimuli. And so when they looked at men who had offended sexually against children compared to all other groups, they showed significantly more arousal to the child scenarios than the other groups. And then when they compared men who had sexually offended against prepubescent children versus men who had not sexually offended, we see these really large Cohen-Ds kind of differentiating between the groups, with the combined and the pedophilic being the highest, probably because there's a lot of overlap, that the combined group was the one where they just used the word children but didn't identify the age. Probably they were prepubescent. Okay, so then I was curious, is PPG used in Australia? And I found this article in the Australian Broadcasting Corporation, where the title was, "This penis lie detector helped doctors conduct gay aversion therapy." And so there was a Sydney-based psychiatrist who in the 60s and 70s had this homemade penile plethysmography, or plasmograph, that he used. So that was one thing that I found concerning. So then I looked at the literature, and there was a paper published in 2021 where they were looking at international academic interest in philometry, or PPG. And I think they were measuring it by affiliation of the first and last author. And they identified that only 0.8% of those articles were from a first or a last author whose corresponding address was in Australia. And then I thought, well, what about in private practice? So I could only find one private practice website in Queensland where they identified themselves as the only forensic service in Australia that has the capability to use polygraph and penile plethysmography in the assessment and treatment services provided. And it looked like the individuals who opened that forensic practice either trained or worked in the UK for a while. And so I think that was the reason for that. So based on the very limited things that I could find on the internet, I don't think that PPG is used in Australia. And then lastly, I want to talk about specifically conducting Serious Offender Act evaluations. And so from the statute, I learned that when you are asked to conduct an evaluation pursuant to this act, there are what they call assessment reports and progress reports. And so the content of the assessment report should have whether or not that individual has a propensity to commit a serious sexual offense or a serious violence offense, or both in the future. They want the pattern or progression of the sexual or violent behavior to be described, and whether or not there's any indication of risk for future behaviors. They want a description of any efforts made by the individual to address these behaviors that might be making them high risk, whether or not they participated in any kind of rehabilitation or any kind of treatment, and whether that participation had what they call a positive effect. They want information about their background, developmental, social factors, other offenses that might not qualify under this act. They want a description of factors that might increase or decrease their risk, and then the results of other assessments and, quote, any other relevant matters. And then similarly, the progress report, again, looking at whether or not they have the propensity to commit one of these offenses or both in the future. And then specific to the past 12 months, what efforts that person has undertaken to address the causes of these sexual and or violent behaviors. Again, whether or not they participated in treatment, whether that had a positive effect. And then same as the last slide, any factors that might increase or decrease their risk. And any other relevant matters. And so I guess the major difference is these are individuals who have been under supervision or detention orders, and this is looking at their progress. So these reports don't require the development or social history, but pretty much everything else looks like it's the same. And then from the statute, for both of these types of report, they have to state, quote, the medical expert's assessment of the risk that the person will commit another serious sexual offense or violent offense, or both, if they're released into the community and are not subject to a detention or supervision order. Okay, so I think that the key message, hopefully from this talk, is that these evaluations pursuant to the Serious Offender Act require really careful integration of thinking about culture, using appropriate measures for the individual that you're assessing, like knowing and acknowledging the limitations of our risk assessment tools that we have. And consulting multi-methods and not relying on just one data point for any of your opinions. I'd be glad to take any questions that you have.
Wonderful. Thank you very, very much, Emily. That was a fantastic presentation, very comprehensive. Okay, I'm going to stop sharing and bring the lovely people online here. That's all to say. Right. Okay. Now, I can start to take questions or comments. Okay, so I'm just going to start with, there's just some general comments. You can see them up here. So Marie Henshaw said, in Australia, audio and written descriptions of sexual activity with children will meet the legal criteria for CSAM. So unless there was a medical exemption, we wouldn't be able to use the methods you use in your labs.
Thank you.
Okay, and we have a comment from Christopher Drake. Okay, just another clarifying comment, a bit of history there. Does anyone have any questions for Emily? Okay, I might start. So I was really, I don't do any work in the area of risk assessment and sexual offending, but it was fantastic and interesting presentation. But I do some research in the area of kind of cross-cultural differences, including kind of differences in First Nations and non-First Nations results with the risk assessments. The pattern we see, and I think that's kind of consistent perhaps with First Nations populations, isn't so much kind of overestimation of risk, but kind of underestimation when you look at calibration. So the outcome rates tend to be higher across basically every kind of risk level we're looking at, particularly pronounced at the lower risk levels, which does affect obviously prediction, but not in the same kind of way that was suggested. I'm not sure if that's kind of the same in the States, but it tends to be a fairly consistent finding, which I think is driven by the base rate differences that you spoke about earlier. We have higher rates of justice contact, of course.
Right. Yeah, and I think that's why it's so important to have local norms for the measures that we use, and that is such an important research undertaking.
How do you kind of reconcile that if the kind of population, like for instance, you spoke about kind of some of the data that you'd kind of found from Victoria, where the population you were looking at, although kind of Aboriginal individuals were overrepresented by a huge amount, they still make up the minority of that population. So any norms that you develop on that will, of course, kind of not be calibrated to that group. And there's a trade-off between representativeness there. Do you have any thoughts about how to get around that?
No, I think that's a really good point, because, I mean, you have some base rate issues. So, no, I mean, there are some really great papers that Shepard wrote with some recommendations, but no, I wish I had good recommendations for that.
All right, yeah. Okay, well, something for all of us to think about, I suppose. Does anyone here in person have a question? No? I think it's because it was so comprehensive. You covered off basically everything that everyone was going to ask and wanted to know. Okay, wonderful. Well, I think that nicely brings us to about 5 o'clock, which is fantastic. I wanted to thank first of all, thank Emily for coming all the way from the United States, especially for this seminar. And of course, our audience joining us online and in person, thank you very much.